Hello everyone, this is my video discussion for session 5. I will focus this video discussion on the first section of this lecture, which is related to the theory of morality by Immanuel Kant. I would like to discuss 2 points. One is a practical case. It is related to the trial of Adolf Eichmann. Eichmann was one of the main responsibles for the Holocaust, as he was in charge of the logistics of the mass deportation of Jews to concentration fields. What is relevant in this case is that in his trial, Adolf Eichmann claimed that in implementing the final solution, he was acting from obedience to the law, and that he derived the morality of his actions from the reading and the interpretation that he had of the Kantian principle of morality. This account or this case relates to the use of practical reason, and there is also another book by Kant which is called What is Enlightenment, in which he differentiates between two uses of practical reason. One is a public use of reason, in which reason is used in the deliberation that we have as human beings in a public sphere, and the other one is the private use of reason, in which it relates to the reason that one uses when we are employed as a civil servant or as a public official, and under that oath we have to be subject to a legal framework that we have to obey. What I believe that this case, like the discussion that this case may generate, is on the relation that may be drawn from Kant between law and morality. To this extent, I think that from the interpretation of the Kantian morality, a legal framework can only be considered moral if it complies to the categorical imperative in which us as human beings are treated and considered as individuals, as ends, but not as means to a particular objective. To this extent, one can consider that the Eichmann's account on Kantian morality was just related to some blind obedience of law, and not a critical account of what law has to say in relation to morality. The second point that I would like to discuss relates to the conflict of rights. This scenario is very common in constitutional law, in cases where there is a collision between two rights, two fundamental rights. And the question that is raised in this situation is if one right can outweigh another without affecting the individual dignity and the individual as an end and not as a mean for another objective. Commonly, the answer to these cases of conflict of rights relates to the theory of proportionality that has been discussed by many other scholars, principally by Robert Alexy, which is basically a test in which judicial official can weigh and consider if a limitation to one right is adequate or proportional to the end that limitation is seeking. I think that this theory of proportionality is more related to a theory of justice of a consequentialist nature, to the extent that the theory of proportionality is focused on the consequences of the limitation to a right and not to the value of the right itself. And in regards to this topic of a conflict of rights, if one has to interpret this situation on the grounds of the Kantian theory of morality, one could argue that a limitation of a right can be moral to the extent that it seeks, like the objective that the limitation seeks is an end that is morally valuable by itself, such as justice or equality, which may be a good reason for a limitation for a particular right of an individual. Nonetheless, these circumstances of a conflict of right, I believe that may be a good point of discussion for analyzing the theory of morality by Kant. But well, I believe that to the extent that we limit this conflict to some objectives that are morally valuable in themselves, it may be justifiable to limit a fundamental right over another.